Hey, Juanita. Good
Hello.
afternoon. Mark Westcott here. Juanita Maiden from Murdoch's, and with you today on estate and succession mastery. So looking forward to some good conversation today around reasons why young people need to have their wills sorted as well. We tend to think mostly that it's up to mum and dad to get all their stuff sorted, but Juanita is here to tell us 50 reasons why.
50. I don't know about 50, but I got quite a few. It's certainly a topic that I hear a lot, and we lawyers hear a lot. Unfortunately, not necessarily when they're in our office, because there's a perception that young people don't need wills, but it's certainly something that I hear a lot in conversation out and about, and hopefully after today's session we will debunk that myth, Mark.
So we should call this the Mythbusters.
Mythbusters, the Wills and Estates Mythbusters.
We'll get our own TV show. No, that's great. Look, I this is something which is obviously very, very close to your heart. But something that just struck me straight away when I was thinking about this today, as I do about 5 minutes before the sessions, was
we plan for weeks. We plan well ahead.
You plan for weeks, and I make it up on the spot. That's how it works. But no, I was thinking, what happens, and I've seen this before, is where there might be two children, for example, and mum and dad. Let's just say a really simple scenario: mum and dad leave X number of dollars to each of the children. One of the kids is married with, 3 children, and the other one's still single. The danger is what happens if money's been left to both kids. The single one dies. How do you guarantee that that money's not going to disappear off to somewhere where it shouldn't be, and vice versa?
Yeah. Well, I've got a list of I've got a list of 7 to start with. So if you're happy, I'll walk through my list. I think that that probably the starting point is a lot of young people would actually be surprised if they sat down and worked out what assets and net assets they do have, because the initial reaction is, we don't have anything, we don't own anything, we don't have enough to make a will. And you would be surprised. So when you sit down and you add up cash in bank accounts, motor vehicles, jewelry, perhaps the big one for young people is superannuation. Usually that knocks them off the socks. I actually do have a bit, which needs to be dealt with specifically, as we've discussed in our sessions before. Then that gets the mind thinking, okay, now I get it. I actually do have more than I thought I did. So, that's the starting point. You would be surprised how much you actually do have, even though you're a young person at the beginning of your career and family life.
Well, and you touch on superannuation there, Juanita, and I mean, that can just be an unknown amount, can't it? Because for a lot of people, there may be life insurance as part of their superannuation fund. They may not have accumulated a whole lot of assets, but I mean, on their death, there might be a $400,000, $300,000, $500,000 payout.
Yep.
To who?
Yeah, that's right. And so it's really important and most young people, to be fair, most people, are able to articulate what their super balance is. So that's certainly something that would surprise them. And the point being, if you don't, probably we should talk about what happens if you don't have a will. And what I was about to say is that it might not go to the person or the people that you want it to. And that's really one of the bottom lines, is probably one of the major points here. So to give you a bit more explanation around that, what happens if you don't have a will is basically your estate is distributed pursuant to what the law says. So there is a formula, and it will be distributed to certain categories of people in order in certain shares. So there's no discretion, there's no choice. That's what happens. So you can quite clearly see that might not be who you want it to go to and in what proportion. So that's the number one reason why you want to have a will in place. So you'll be surprised what you actually have, and you want to make sure that it goes to who you want it to go to and not who the legislators want it to go to.
Yep. May I cut in here?
Sure.
With an example, or do you want to keep rolling because you're on a roll?
No, please go ahead.
Okay, I think we've talked about this before. An example I had where a son had been living with his girlfriend. They'd been together for a couple of years. He basically had close on $1 million worth of superannuation through life insurance and so on. But you know what had happened along the way was Dad had helped him with his business. He'd lent him a whole lot of money. He'd helped him with cars and a deposit on the home and all that sort of stuff. So Dad had actually, you know, lent without any agreements, obviously, a whole lot of money to the son, and the son died. Son died in a terrible accident. So you can see where all the, you know, so the $1 million basically went to the girlfriend. You know, where they didn't have any debts together. I mean, they didn't have any financial arrangements. They'd been living together for 2 years, and Dad was left high and dry and never saw any of the loans effectively that had been made to the son. Whereas, you know, simple things like not just a will, obviously, but binding nominations for the superannuation fund and all that sort of stuff, and maybe some loan agreements might have been good value along the way. But you know, that in itself is, you know, because of the 2 years for the living together, all those sorts of things. So the law can really jump in the way of some good intentions.
Yeah, that's right. And to sort of to talk through that point, a lot of young people that might not be married with families will be in a relationship, and for the purposes of succession law, which is the law of wills and estates, if you have been with a partner for 2 years up until your date of death, they have legal rights to your estate. So for young people out there that might say, oh, I'm not married, I haven't got a family, that is another one of our reasons that I wanted to highlight today. So if you are in a de facto relationship for these purposes, which is over 2 years, well, then you need to have a will in place, because that can and often, it may not, but we often see disputes in that situation where a young person passes away and their estate is divvied up between their, well, depends if you want to call 2 years short or long, but it's certainly not a lifetime relationship, is it? No. And the family, there can be some nasty disputes between family members, a mum and dad, for example, and the partner of 2 years and 1 day that, all of a sudden wants to get, well, I shouldn't be presumptuous, but, may feel they have certain rights where the parents may feel they don't. And everyone has rights in that situation. But, so to avoid disputes, another reason why, if you're in a longer term relationship such as that, it's certainly if you're over 2 years, then you really should have a will in place and put some thought into how you want your estate to be distributed. If we keep working through that example, that sort of covers where you're in a de facto relationship short term. When you get married, we often will see a lot of people, young couples with young children. So, you might be in your 20s and you've got 20s, 30s, a young child, one or two young children. And I hear the same thing. Well, we don't really have much. Again, you'd be very surprised what it adds up to, particularly in this situation. So if something was to happen to both of you at the same time in a common accident, for example, and your minors were left behind, we're adding up 2 estates. So we're adding up, in likely scenarios, a home, bank accounts, 2 lots of super, 2 lots of life insurance, and all of a sudden it is very, very, very easy to top that $1 million mark. And would you want your 5-year-old all of a sudden getting $1 million with no parameters around it at all? And I would say 100% would say no. So putting a will,
unless you were the 5-year-old, right?
Yeah, well, probably right. So putting a will in place is essential in that scenario, because it allows you to put some parameters around what would happen if both of you passed away. So things like who would look after the money for your 5-year-old. You can put in place, a letter of wishes that explains how you would want your child to be brought up and how you would want the money spent, etc. So really important reason for young couples with young children to put a will in place. The other part of that scenario too is that if one of you pass away, so same situation, young couple, young child or children, if one of you pass away, most people assume, well, it's all going to go to my spouse anyway. But if there is children involved, that's not without a will, that's not the case. So we can sometimes see, so again, there's a formula. So if I pass away, my estate will be split without a will between my husband and my children. Sometimes that's problematic because we have seen situations where the family home might, because of the formula, or a property might have to get split in ownership between the spouse and the child. And you don't want children's names on a title to the home where the spouse is therefore restricted in things they can do because of that. So it can be really problematic. Certainly the spouse will get most of the estate, but the children will get some. And again, you haven't put any parameters around who will look after that money or how you would want that spent, etc. So you can already see all these issues that can come up for young couples with young children without wills. It's really important to put a will in place. Another reason in that same scenario, while I'm talking about it, Mark, is guardians. So in a will, you are able to put in place who you wish the guardian of your minor children would be. So again, I've never come across anyone that doesn't feel strongly about that and would go, I don't care, whatevs. But we'll let them work it out. So in your will, you are able to put a wish as to who you would want the guardian or guardians of your children to be if both of you were to pass away. So that's a really powerful ability to put that in your will. I would add a proviso that at the end of the day, if there is a dispute, the family law court has the final decision in the child's best interest. But having a wish in your will or a direction in your will holds a lot of weight in that circumstance, and particularly when there's no other good reason why the guardian wouldn't be the guardian of the children.
Yep. Just going to make comment. No. When you get on a roll, I dare not interrupt. But I mean, someone's made a comment here and just said, anyone over the age of 18 needs a will, younger if in the services. And I understand where the emphasis is coming from in regard to the services, but I mean, that's not the only thing that's going to risk your life joining the services. So I think everyone needs a will, services or not. Absolutely.
Yeah, so you certainly you need to be 18 to do a will, except for certain circumstances. So examples, military situations, or also if you're I suppose unlikely scenario, married as a minor. So there are some extenuating circumstances where under 18 you can get a will done. But usually. So everyone, exactly. I agree with the comment. Everyone over 18 should have a will.
Yeah, is that so? If you're not 18, you can't have a will. Is that the point?
With some certain exceptions, yeah. Apart from some.
Okay, generally speaking. So what if you're 15 years of you've wealthy family with kids in their sort of early teens and so on, and there's a multi-million-dollar estate, and let's say the parents haven't done a proper will, so everything just gets left to the children. What happens if one of those children then, who's a beneficiary of that estate, might be 14 years of age and has $3 million sort of ticked to that they're a beneficiary of? How do they nominate what happens there, or is that sort of held in trust by in the case where there's no will, a public trustee or something for the benefit of for them to work out who the money goes to?
Yeah, so another reason why you should have a will is because without one, someone needs to apply to be the administrator of your estate. And in the case where the example you gave, so someone would need to be appointed as trustee for those funds on behalf of the children. And who depends on the circumstances, but that's just sort of going back to the example I said before. You certainly wouldn't want a $3 million trust fund in place without nominating who's going to be looking after it, or when the child takes it also, because otherwise they'll automatically take it when they turn 18. Most people we see would rather the children take those funds when they're older, 25 or 30, etc. So we want them to turn 18 and all of a sudden take the money and blow it. We're talking a lot about wealth too in a monetary sense, but I think it's also important to note that some things are more of sentimental value. So often in will disputes, we'll see disputes that come down to the things that are mostly of sentimental value, like family. The last thing to be nutted out is the family heirloom or the the jewelry that's been passed down from grandma. So
grandma's wedding ring.
Yeah, absolutely. So when we talk about assets being, you might not realize how much you own, we shouldn't forget that there are assets of sentimental value. And when we do a will for people, we'll always ask, is there anything of personal nature that you want to specifically gift in your will or in a separate letter of personal effects? Because it may be that family heirloom or that wedding ring that you want to pass down to your first child or, your only daughter or that sort of thing. So it also allows you to give those items of sentimental and personal value, even though to anyone else they may not be of great monetary value. And I'm sure you would have seen heaps of examples of that sort of thing too, Mark.
Yeah, I'm not sure what number you're up to, but can I just cut in here and ask a question? Is that okay?
Of course it is.
Okay. What percentage of people in Australia have a documented will that's current?
Oh, I don't know the exact percentage now, but it's less than half.
Yeah, so it'd be 60-70% of people probably don't have an up-to-date or current will, do they?
Yeah.
So if a young person goes out and gets a will when they're young, I mean, I know when they get married that negates that will, right? So, but if they get a will when they're 18, even if it's a basic one, but at least give some direction in regard to making sure mum and dad would be looked after if there were loans there, and giving them the opportunity to maintain that the money stays within the family if they receive any inheritance and all that sort of stuff. There's probably a very high chance, and I'm being contrary here to what we're trying to encourage people to do, probably a very good chance that they're not going to do another will until they get married anyway, are they? So hence what a great idea at 18 years of age to go out and get something done to protect whatever may come in the future. So you're kind of making a will at 18 in contemplation of what may happen as you're going through life, and just in case, which is probably most likely, is that they don't do another will until they get married or later on in their life. So if for no other reason, at least you've got one. It's sort of like at least you've got one there, and at least you've thought it through to make sure that family is protected and any inheritances that come down stay within the family environment.
Yeah, you're right. And sort of practically, you can see that situation panning out exactly that way, where a young person will put a will in place, and then life will carry them over the next 10 years. We're talking about an 18-year-old, and at least then they, as you said, marriage will revoke a will. A lot of people don't know that, and then you're left without a will again. So you need to do a new one. There is also an exception if you do a will in contemplation of marriage, then that's also allowable. But in the circumstance we're talking about, that would be the case. So it crossed my mind that maybe our parents out there would like to give their children a quirky little 18th or 21st present and pay for them to do their new will. And it only needs to be a basic will or enduring power of attorney. But it's a great idea, Mark. It's a great idea. It's not the most usual present, is it? But I like it.
The 18th birthday present.
Not the keys to the car, but
when we used to turn 21 and they'd give you a big key with whatever on it, and 21 was a big deal, and I guess these days 18 is, I suppose, or I'm not sure, but at 18, my point is because there's such a low number, which we're trying to alleviate, obviously, and improve on, at least if they get something in place which is sensible, for goodness sake, not a will kit from the news agency. We're talking about having put some thought into it and ensuring, as I say, wealth stays within the family and parents are looked after if there's been loans and all those sorts of things. So at least they've got something to see them through. Yep. But anyway, I've interrupted you. Probably up to number 3, and you've got something to go.
No, we're going all over the place. It's great. We touched on before what happens when you don't have a will, and I briefly mentioned that someone needs to apply to be administrator of your estate. And what I mean by apply is apply to the court registry for a grant of letters of administration. Now, two things about that process. Well, three things actually. One, that might not be the person who you want to be administrating your wills. So for your estate. So for example, you might, it might be your wish that if you passed away, your mum or your dad administered your estate. And look, that might still be the case because the law puts down a hierarchy of people that can apply to be the administrator of your estate, but it might not be who you want. So point A there is with a will, you get to appoint your executor, which is a person or people that you want to look after your estate and carry out your wishes when you pass away. And the person that you think can handle it too, because it might not be, you might want to perhaps have your older sibling do that because you don't want to burden your parents with that. These are the sort of things you can think through. So it allows you to appoint who your executor will be.
Yep.
Having a will instead of not also eliminates that whole process, which can be costly and time consuming. So you might think you're saving, X dollars by not putting a will in place, or it's too expensive. I can promise you it'll cost more if you need to get a letters of administration and go through that process because there is no will. More costly without having a will.
Hence a good reason why mum and dad should spring the 18th birthday present.
Absolutely, sure.
Because they'll be the ones paying at the other end if they don't.
Yeah, that's right. And that whole process can take time, and it can be really stressful for the people that are left behind, that are, squabbling or dealing with super trustees and with the various asset stakeholders without that document and need to go through that whole process. It can be really time consuming. So without a will, in summary, you can't appoint who you want to administer. The whole process can be more costly and it can take longer. So again, much easier to put a will in place for those left behind.
So for example, if a young person passes away, mum and dad are still around, they might end up dealing with a public servant at the public trustee office, for example, is probably who they're going to be dealing with, and that in itself could just be an absolute nightmare for them. That's what you're saying.
Yeah, absolutely.
Potentially. Yeah. There's nice people work there, but it's
Well, it's a paperwork nightmare, isn't it? It's more that it's stressful. It's dealing with things that some people haven't dealt with before. So that certainly makes that whole process tough.
Yeah, and at the time, and I often talk about emotional paralysis, and I mean, a parent losing a child, for example, and the child hasn't done a will, I mean, the parents are going through grief that I just would never be able to comprehend, but also then having to deal with stuff that you just don't want to deal with, and having grief and aggravation, going through a process that could have easily been averted. There's a whole lot of reasons why everyone should be encouraging their children to make sure. In fact, I'm getting on the phone to my daughter after this. I'm pretty sure she's got one. But there's a whole lot of reasons why you'd want your kids to make sure that they've got their plans in place.
Yeah. We've sort of covered the main reasons, but a couple of other quirky reasons come to mind, and some examples that I've come across in matters. These days, you are able to direct in a will how your social media accounts will be dealt with on your passing, and you'd be surprised what a painful experience it is to try to deal with social media, like your Facebook, your Instagram, your Twitter, your LinkedIn, all that sort of thing for the people left behind. If they don't know your passwords, or if they don't know, don't have the authority to deal with that. So there are things you can put in wills that you can that can assist them deal with your social media accounts, or at least put down how you would want to be dealt with them.
Yep.
Another quirky little thing that we'll often see in wills, not often, but not unoften, is dealing with pets. So in your will, you can express how you would like to your pets to be cared for, by who and how, and sometimes leave a fund to assist with that, although that's sometimes problematic because you need to think about what will happen after the pet passes away, etc., etc. But you certainly are able to put some wishes down as to who and how you want your pets dealt with after you pass away.
Is that why you've got your pet with you in the office here today?
I do have my pet with me today. He's around here somewhere, but if he comes back, I'll pop him on camera.
Make him
for
famous.
Bonus cute points. And another a little outside the square thought too is a lot of people haven't thought about this, but you can in your will put down wishes as to your burial or your cremation or your funeral, etc. So I've certainly seen in matters that I've been involved in, family members or alleged de factos or different members of the family in dispute over how a funeral should be carried out or how a deceased person should be buried or cremated or under what religious beliefs that should happen. And that's one of the really nastiest types of estate disputes that we come across, to be honest. So if you have particular wishes about that, then please put them down in a will, because it just takes that whole dispute out of, that it just won't happen. And that can just be so horrible and costly and stressful for the people left behind.
I'm just going to, if I may, Juanita, just give what we do a bit of a plug. And one of the latest things we've sort of released, but we're about to release in the next few weeks, is a process called the Family Legacy Letters. And in the Family Legacy Letters, it's all the things that you've just been talking about, all the human elements. Where do you want to be buried? Do you want to be cremated? And all that, because my thesis is that, as you've said, that, imagine someone dying that everyone loves, and then all the people that are grieving are fighting with each other over whether to bury him or cremate him, or where he wants his ashes and all that sort of stuff. And if you can take away, my thing is, from my experiences, if you can take away all the areas from people where there's likely to be a bust up or a blue or a squabble after you've gone, and leave instructions and directions for people, then you're just doing everyone a favour, and you're saving the relationships that are left behind, because they're the sorts of things that people will argue about and then never talk to each other again. After you've gone, they're arguing over where to bury you, and those family members are likely to blue so much that they'll never communicate again. So you're really saving families if you can leave some instructions. I always say leave clues. Write things down. Say where you'd like to be buried. Say what church you want to go to or whatever, and just make it easy for people. And one of my favourite lines is never leave anything left unsaid. So, with the legacy letters that we're helping our clients with, it's the opportunity everyone has to make sure they say what they'd like to have said to those left behind. And that applies to grown-ups as much as it does to teenagers and young people, which is who we're talking about today. They're things that young people should do as well, to make sure that the parents who'll be grieving unbelievably the loss of a child, leaving things behind that you'd like to say to your parents to thank them and show gratitude would just be the most valuable gift you could leave. So yes, the human elements are very important in the whole estate planning process.
Yep, absolutely. Well, we're almost out of time. I could go on with some more things, but we're almost out of time. But we've covered quite a bit, and I think if we'd started, what I said when we started is, hopefully by the end of this session, we've given plenty of examples of why a young person or why a young couple should have a will, and I'm sure that at least one of those things has resonated with any young person that's listened, or with any of our parents that have listened, as to why it's a good idea to encourage their children to put it in place a will. Yeah, absolutely. Just one more thing too. We're just doing a webinar at the moment online, successionchat.com. If anyone would like to just go in with the title of the webinar is "The Good, the Bad, and the Ugly of Rural Succession Planning." So, which one are you, Mark? Thank you. I'm not the last one, hopefully. Hopefully I'm the first one. Really good.
the good guy, not the ugly guy or the bad guy. But successionchat.com if you want to go on and register for that. It's online. So, but Juanita, once again, thanks for all your wisdom again today. You know, we're out of time already, but really appreciated that. There's a whole host of reasons, not just the 7. We sort of expanded our past there, but reasons why young people should get their estate planning done to just make life easier for all those left behind. And, you know, it does happen. So best to be prepared. Thanks, Juanita. Appreciate it.
Thanks, Mark. Thanks, everybody.
Have a good week.